Okay. Okay. So let us again start with the trade secret, right? So in the first session, we were speaking on the trade secrets, and in that we were speaking about the trade secret. We are going to continue from the same. So as we have seen, trade secret is an intellectual property in the form of a formula, maybe the practice, design, instrument, and pattern, with which it is very important. And if it is known, generally not known to the public, that is actually a secret information with which the business can obtain the advantage along with its competitor and customer. The reason is with which the other Coca-Cola is famous because it is a secret. What kind of ingredients or what kind of combination about the mixture is being used, it's a trade secret to them. Really sorry. Yeah. So that needs to be taken into consideration. So similarly, let me just again proceed further. So let me just, yeah. Since I was speaking on the trade secret, we have been using the same. Now, going further, what should be done if that trade secret is violated? It is always expected that the trade secret is not violated because if that secret is revealed, the secret is no more secret, right? So that is the reason usually company use the employee non-disclosure agreement. Whenever they hire, they normally have a non-disclosure agreement to protect the confidentiality of the secret of the company during and after the termination of their employment. It means if any person is relieved or if the person leaves the organization, he is not supposed to reveal any confidential information of the secret of a company during and after the termination of the employment. That is comes under this. Third one is the trademark. Trademark is nothing but a trademark is nothing but a recognizable sign, design, or I can say an expression by which the customer can identify a product or a customer can identify a source of a product distinctively. So normally you might have seen in you can see you might have seen in various ways in various websites and in various things that you have a symbol TM, that is a trademark. That's a trademark symbol. Or you have seen R. R stands for the registered trademark symbol. So it is used to indicate the trademarks by the owner. So trademark example demonstrate how the names, how the words, and how physical marks can be used to distinguish the business from competitors. So you can have a trademark, you can have a registered trademark to ensure that your business is protected from the competitors. The competitors cannot take your name and he cannot create any copies of it, right? So it provides protection to the trademark for goods and service and also to prevent any fraudulent use of the mark in India. So this trademark in India is registered and protected by the Trademark Registry Act, which was established in 1940, and its act was under the Trademark Act in 1999. So what it does, it does provide the protection to the trademark for goods and service and also to prevent any fraudulent use of this thing. Now, next one is the copyright. A copyright is actually the legal means of protecting the original creativity work of the creator. So what it does, it gives you exclusive publication, distribution, and usage rights to the creator, and it cannot be used, reproduced, or published by anyone else without someone's consent, right? So copyright only protects the original expression of the ideas, but not the ideas itself. So you can copy the ideas, but at the same time, it is the protecting the expression of the ideas, right? So protecting the expression of the ideas comes under the copyright. So for example, I'll tell you if you have a lot of songs, if you have taken a songs which is there in the public domain, and then you have arranged the sequence in which that song would play, it's a copyright because you have taken the although it was in a public domain, you have taken an effort, you have taken it to arrange in a sequence, you have arranged in a way it needs to be performed, the way in which it needs to provide an output. It's something a new idea, and that the expression of idea can be protected with the help of a copyright. So copyright only protects the original expression of the idea, but not the underlining idea or the idea itself, right? So copyright ideas is there for a limited amount of time, after which the copyrighted item can be used freely by others. The creative work that can be copyright includes you can have a copyright on a books, you can have a copyright on poems, songs, films, websites, online content, and other creations. So copyright office is set up to build and to protect the Copyright Act, and it is set up as per Section 9 of Copyright Act 1957. Just see, it is we are Copyright Act is as per the Copyright Act 1957, which came into effect in January 1958 to provide the copyright protection to all types of work. So it is under the immediate control of the Registrar of Copyright, which is appointed by under the directions of the central government. So that is what you have. Okay. Next is, let us see next the intellectual property laws and the cyberspace in India. What are the intellectual property laws and what is the cyberspace in India? Now, to answer this, as we all know, there are a lot of content is published on the internet every day in different formats. The internet is the ideal medium for the creators of the artistic content to spread the work to large audience. So as you know that people can also edit, people can also distort, or people can also redistribute the sound, the video and image they find on the internet either legally or illegally. Right? You might see there are several things which everyone keep on posting, whether it may be legal or it may be illegal or whether it might be a copyright. So there should be something. There is a true for casually posted content on the social networking website, as well as there can be can be intellectual property theft. So piracy of movies, piracy of the software, which causes huge loss of revenue to the copyright holder, because it is someone else content and you are using it. So it causes huge loss of revenue to the copyright holder. And because of that, the Indian Copyright Act 1957 deals with the protection of that software. So Indian Information Act 2000 has no provision for the protection of intellectual property rights, but the Indian Copyright Act deals with the protection of computer software, and because of that, it is making use of the intellectual property rights. Right. So next, in the next slide, we are going to see the section 2 of Indian Copyright Act 1957. So this is the Copyright Act of 1957, and if you can see, this Copyright Act 1957 is an amended by Copyright Amendment Act 2012. It was amended in the year of 2012, which governs the subject of copyright law in India. The Act has been applicable from 21st January, as we have seen, 1958, and has been amended from time to time. So if you can see here in section 2, it is clearly written, and it is including a computer program as a part of a Copyright Act. So computer program means a set of instruction which is expressed in words, codes, schemes, or in any other form, including a machine readable, capable of causing a computer to perform a particular task or achieve a particular result. So entire section 2 is been given, which is given what it covers, what it enrolls, and everything information is there in the Copyright Act of 1957. So the section of Copyright Act 1957, if you can see, is there to provide the original, literally, dramatic, music and artistic work for cinematography films, for sound recordings, and so on. So the following section of Copyright 1957 is related to copyright infringement of software or computer programs and the punishment to the offense. So if you somehow do an infringement and if you somehow break the law, then you are punishable under the section 2 of Indian Copyright Act 1957. Right? Section 63B is also been used for knowing the use of infringing the copy of the program to an offense. So any person who knowingly makes use of a copy or any person who makes use of a computer for infringing a copy of a computer program shall be punishable with imprisonment for a term which shall not be less than 7 days, but which may extend up to 3 years. So just see, if we are punished under section 63B, you can have an imprisonment which shall be not less than 7 days, minimum 7 days, but which may extend up to 3 years, and with a fine which shall not be less than 50,000 rupees, but which may extend up to 2 lakh rupees. So if you are caught under it, then you need to pay first maybe imprisonment, which should not be less than 7 days and will may extend up to 3 years. And second, amount which should not be less than 50,000, but it can extend up to 2 lakh rupees, depending on the situation. Depending on how much program you have been gained or you have used in the code or business. Clear? Now let us see the next, which is called as an evidence aspect in cyber law. So when we speak about an evidence, evidence is nothing but a proof which needs to be presented in a law of court to make sure that it can be presented in a lot of court to authentic truth in any matter. So for that you have an evidence aspect in cyber law. So when we speak about the evidence aspect of a cyber law, in legal terms, evidence is nothing but a proof presented in a court of law to ascertain the truth of a matter. So I have written here also. So you can refer my slide. In legal terms, evidence refers to a proof presented in a court of law to ascertain the truth of a matter. So it is nothing but a piece of evidence which is used to prove certain questions, or to prove or disapprove any fact, or to approve any fact, and it can be presented in a law of court to come to a conclusion in any legal basis. So for that, you require an evidence aspect in the cyber law. So pieces of evidence are produced by all the parties in a legal dispute. So for that, whatever evidence you have, for that, what are the types of evidence considered, and what are the types of evidence that you can present in the court of law comes under the evidence aspect in cyber law. So the next slide, we are going to see what are different types of evidence, and we are going to understand the different types of evidence. Clear so far? Any doubt? So as I said, from module number 4 to 6, we are all going to see everything based on the cyber law is concerned. In the previous module, we have seen a lot on cyber crime or cyber security. Okay. Okay. Thank you so much. Now, when we speak about what are the evidence aspect in cyber law, in that I was speaking about what can be the different type of evidence that can be considered. So when I say a law of evidence, it is nothing but the rules of evidence. Is an important part for both the civil law or for the criminal law. So it is a set of rules that authorize how to collect, present, and apply evidence for each case in a court of law. So Indian Evidence Act 1872 is the primary law which defines the rules of evidence in India. So when I say about the types of evidence, you have various types of evidence. So if you can see, you have testimony, you can have a real evidence. Real evidence, it means a physical evidence. You can have a demonstrative evidence, or you can have a documentary material. So this all can be a part of your types of evidence is concerned, right? So in this, if you want to check, you can see when I speak about an evidence which is a testimony, your oral or written statement or the affidavit can be considered as a part of an evidence. If you have an oral statement, if you have a written statement, or if you have an affidavit, that can come under evidence aspects of an cyber law. Second is the real evidence. Real evidence is the physical evidence, like tangible items like weapon, maybe the object. So that all things can be presented in a court of law as an evidence, and that is nothing but a type of a real evidence. Demonstrative evidence. Demonstrative evidence means any evidence in the form of pictures, X-ray, diagram, map, drawing, graph, animations. Everything are a part of a demonstrative evidence. And fourth type is a documentary material. So anything in a form of a letter, anything in a form of invoice, contract, this comes under the documentary material. So these are the types of evidence that comes under the evidence aspects of cyber law. So in the next slide, we'll go further and understand what are the act that has been made for the Indian evidence. Okay. So in India, the Indian Evidence Act was enacted by the Imperial Legislative Council in 1872. Just think, 1872, it means at the time of British rule. So using that rule till today. So in India, Indian Evidence Act was enacted by the Imperial Legislative Council in 1872 during the British rule, which contained a set of rules and all the issues which is governing to the admissibility of evidence in the Indian courts of law. Right? So it was something that governs the admissibility of evidence in the Indian court of law. So Indian Evidence Act is identified as Act number 1 of 1872, and it called as Indian Evidence Act 1872, which came into picture in 1st September 1872, and since then it has retained its original form, except where there are certain amendments done from time to time. So there are certain changes been done from time to time, but otherwise it is the same Indian Evidence Act which we are following from 1872. Right? Since we are done with the evidence and the Indian Evidence Act 1872, let us go further and understand the criminal aspects of cyber law. Okay, clear so far? Okay, thank you so much. Yeah. So now let us proceed further and understand the criminal aspects in cyber law. I'm sorry. Okay. So when we speak about the criminal aspects in cyber law, let us understand what the crime is first. So crime, as we all know, it is nothing but an unlawful act that is forbidden and punishable by the law. So it is an act that could be harmful to an individual. That is an act which can be a crime can be harmful, or the criminal aspects in cyber law can be harmful to an individual or to a community, or can be to a society or to a state. So same is true even if it is done using technology. And we have seen by the name called a cyber crime. So if you remember, we have seen in chapter number 1 about what is cyber crime and what are the different types of cyber crime. And there are various types of cyber crime we have seen. So we have seen all the different types of cyber crime in chapter number 1. I do not want to take it again. So in chapter number 1, we have seen that there are various types of a cyber crime, and to combat against such cyber crimes that we have seen in module number 1 about different types of a cyber crime, India enacted the IT Act 2000. So again, the entire details on IT Act 2000 we'll see it probably in module number 5, when we are going to speak and understand IT Act 2000 and IT Act 2008. Amendment Act of IT Act. That also we are going to see in detail probably in module number 5. But then to combat against cybercrime, India enacted the IT Act 2000, which amended various existing laws related to cybercrime in India. Okay. Okay. So now let us go further and understand the Indian Penal Code of 1860. So the Indian Penal Code of 1860, Indian Penal Code in drafted, which is in 1860. Just check which year again. The Indian Penal Code drafted in 1860 is the official criminal code of India. It provided a general penal code for India, and it is applicable throughout the India except for the state of Jammu and Kashmir. So it contains, Indian Penal Code contains 23 chapters. In that 23 chapters, there are a total of 511 sections. So probably if you have a time and if you're interested in the law, you can actually go and read. There are total 23 chapters in the Indian Penal Code. Don't worry, we are not going into that depth. But then if those are interested can actually see that in Indian Penal Code, we have total of 23 chapters. Inside there are 511 sections. So it contains 23 chapters with 511 sections. So IT Act 2000 has made several amendments to the Indian Penal Code. As time changes, there something change has to be done. So the IT Act 2000 has made several amendments in the Indian Penal Code. So it is again Indian IT Act 2000 we are going to see in detail, but then they have made several amendments in the Indian Penal Code. Due to this, the cybercrime cases in India are also registered under the IPC. So if you have seen most of the time that whenever any cases, or if you might have seen some any legal cases, or you might have seen any shows, maybe if you might have seen Crime Patrol or anything, CID or anything, you might have seen that any punishment is done. They normally say आपको IPC की धारा समथिंग 204 के तहत ये आपको सजा होती है, IPC धारा 405 के तहत. I hope you might have heard such kind of things that happen. It is because Indian Penal Code is there for such kind of things, and that is being followed, which has been defined in 1860. And because of that, if you can see from the screen, there are certain Indian Penal Code. So for example, if you do an offense against public servant, for that you have a section of IPC 167, 172, 173, 175. If you do only forgery, you are punished under section 463 to 477A. If you do any destruction of electronic evidence, if you try to destroy any electronic evidence, you are punished under section 204 of IPC. You are punished under section 477 of IPC. If you have tried to do a criminal breach of trust, you are punishable under 405 section of IPC to 409. If you do any tampering to data, you are punishable under section 489 of IPC. And if you do, if you try to do any counterfeiting, any currency or any stamp, any postal stamp, you are punishable under 489A to 489E. So these are the different sections of IPC, and there are total of 511 sections with which you can be punished according to Indian Penal Code of 1860. Clear? Okay, okay, thank you. Yeah, okay. So if we see, we have right from knowing what is the cyber security and right from knowing the cyber, now we are here where we are learning what are the laws. Because being a cyber security expert, you need to be aware what are the different sections under which if certain breach happens, under what act anyone is punishable to. Right? So based on the Indian Penal Code 1860, as I said, you have a section 463 which is for forgery, which says whoever makes any false documents or whoever produces any false documents with an intention to cause any damage or injury to the public or to a person or is entitled to punishable under section 463 of forgery. Right? So any person commits forgery is if he or she intentionally makes any false document or he or she makes any false electronic record or he or she is a part of any document or electronic record, and if anyone tries to cause a damage or tries to produce an injury to the public or to any person, then he is punishable under the section 463. Similarly, you have section 464 for making any false document, right? So anyone who dishonestly or fraudulently makes, seals or executes a document or a part of document is punishable under section 464 for making a false document. Okay. Similarly, there are various sections available. You have section 499, which is used for defamation. Anyone who remember what is cyber defamation? Yes, students, I think everyone should know this. What is the cyber defamation? We had discussed this in the module number 1. What is the cyber defamation? Come on, at least you can read from the slide and speak. You can write.
So,
Yeah, Khalid, bolo.
defaming a person by cyber means. For example, if you post a photo of a person, which is something which should not be posted,
Correct.
you
Correct.
will be defaming that
Some,
person
yes, 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 yes.
or spreading false information.
Yes. Abu sir, you have raised hand. If you can just write it in the chat box. Yes, Farheen. Damaging the reputation of someone. Correct. Yes. So very good. You are remembering. Intentionally insulting, defamating. Everything is correct. Right? So that is what I am very much happy. Yeah. So yes, you all said very correctly. So if somebody makes any irreparable damage to the reputation of a person, then for that, uh, yes, Abuzer, damaging someone's reputation. Yes, very good. So all of you are correct. So if you are damaging the reputation of a person or of a target person by any which ways are punishable under section 499 of defamation, where whomsoever by words either spoken or intended to be read or by making or publishing any information about a person which is intended to cause any harm or reason to believe that the reputation will harm the reputation of a person is said to defame any person is punishable under section 500. So section 499 for defamation. So in the law of defamation under section 499, which got extended to speech and documents in the electronic form in the IT Act. So the offense of defamation is punishable under section 500, in which you get imprisonment up to 2 years. So if you do that, you are imprisonment up to 2 years, or you are also get some fine, or you can also be charged with a fine plus an imprisonment, or both. So that is there. So this is section 500, which is a punishment for defamation. So whomsoever defames another shall be punishable with simple imprisonment for a term which may extend up to 2 years or with fine or with both. So you can have a different IPC sections that is applicable to cybercrime. 292, 293, 294, 420, 463. 464, 468, 469, 499, 503 and 507. Right? So as we've seen, defamation is nothing but the communication of a false statement that harms the reputation of an individual, reputation of any business, reputation of any product, maybe a group, maybe a religion, or even maybe a government or a country. So the reputation can be harmed or injured, maybe using words, maybe using oral or written words, or maybe by visual representation. So such defamation, when done using computers and the internet, is called as cyber defamation. And cyber defamation is done by publishing any cyber defamatory material using computers. Right? So if anybody does any defamatory statements about someone on platform like social networking websites or maybe a forums on any electronic channel, it comes under cyber defamation, and he is responsible to get punished under various sections of cyber defamation. Okay. So since you have understood this, let us proceed to the next part, which speaks on the electronic data interchange. Now, what is an electronic data interchange? Electronic data interchange is short form, we call it as an EDI. EDI is a computer-to-computer exchange of business documents in a standard format between business partners. So EDI is nothing but the computer-to-computer exchange of the business documents in a standard electronic format between the business partners. So each term is very significant. So when I say computer-to-computer, it means communication done using a computer. So EDI replaces the postal mail, it replaces the fax, it replaces an email. So while email is also an electronic approach, the document exchange via email but still be handled by the people rather than the computers. So if I think that the data is getting interchanged with the help of computer to computer, I mean it is actually replacing the postal mail, that is one which you used to send via post. It is replacing your fax, it is replacing your email. Now we think, why email? Because email is also an electronic approach. But then document exchange via email must still be handled by the people, because there should be someone who will send an email, and there will be someone who will be reading and working on the email. So right, still such kind of a document will still be handled by people rather than the computers. But then having people involved slows down the process, and it might introduce errors also. So instead of that, EDI documents as used, we can flow straight, right, to the appropriate application on the receiver's computer, that is to an order management system, and entire processing can begin immediately, right? So every process, every communication will be taken independently and immediately, where a communication will occur between a computer to computer without human intervention. We call this an electronic data interchange. So if you remember, to make it more clear, we will see what would have been if there would be a manual process, if there will be a manual document exchange, how difficult it is, a cumbersome, and if it's a computer to computer data transfer, how easy it is. So that we are going to see. So the data that gets exchanged in the standard format like purchase orders and invoice, payment details, shipping notice, and many other business documents can be taken into consideration when using business documents. So business documents, as we have seen, that electronic data interchange is the computer to computer exchange of business documents. Now what is business documents? So as the definition says, electronic document interchange is the computer to computer exchange of business documents. What is business documents? So business documents are any form of documents that are exchanged between the business. So the most common document exchange are the purchase order. So you purchase something, a purchase order are the business document, the invoice copy, also the shipping notice, if some shipping of an item is being done. So these are certain business documents that are to be transferred. But there are many others, such as custom documents, inventory documents, shipping documents, plus payment instructions. So all these are a part of a business document, and electronic data interchange is the computer exchange of this business documents in a standard electronic format between business partners. So what is the standard format? Standard format is nothing but it has to be sent in a proper format, because EDI documents are processed by computers and they are not processed by humans. So a standard format is used so that the computer will be able to read the document, computer will be able to understand the document, and the computer will be able to take a decision on a computer. So EDI is nothing but a computer to computer exchange of business documents in a standard format. between the business partners. So without a standard format, each company would send a document using its company specific format. And much as an English speaking person probably does not understand Japanese, and Japanese people will not understand English, same thing will happen if there is no common method of communicating. So that is the reason there should be a standard electronic format, and EDI makes use of a standard electronic format to do a communication between business to business, that is a computer-computer exchange of information, where it has to be in computer-to-computer exchange of business documents, plus it has to be in the standard electronic format between the business partners. Clear? Clear definition? Yes. So electronic data interchange is a computer-to-computer exchange of business documents in a standard electronic format between business partners. Now, what is business partners? Business partners are the people, there may be two different companies referred to as a business partners, or there can be trading partners. For example, company A may buy goods from company B. So company A sends the order to company B. Company A and company B are called as business partners. So those who make the communication are called as the business partners. So by moving from a paper-based exchange of business documents to one that is electronic, business enjoy the major benefit such as reduced costs, increase the speed, reducing the errors, and improving the relationship with the business partners. Right? So it is being used because to have a reduced cost, increasing the processing speed, reducing the error, and improving the relationship with the business partners. Right? So in short, EDI is a standard, is a computer-to-computer exchange of business partners, the business documents in a standard format between business partners. So we'll stop our lecture here. Probably you can join back in the next session in 5 minutes. We'll take it for next session, and then we'll complete it so that we will be able to complete our syllabus sooner. So all of you are requested to kindly join the lecture after 5 minutes. All of you are requested to kindly update your details in the chat box, your number, name, and the roll number if you have still not done it. We shall meet again in the next session. I hope you are enjoying your lecture. We shall meet on the next session.